Welcome back to Legal Brain. In today's class, I'm going to discuss about contracts of indemnity, and this is a very important topic. So listen to the class and try to understand what do you mean by contract of indemnity. First, I would like to give a definition for contract of indemnity, which is defined under Section 124 of Indian Contract Act 1872. And Section 124 says that what is contract of indemnity? And it says that a contract by which one party promises to save another from the losses caused to him by the conduct of the promisor himself or by the conduct of any other person. It is called contract of indemnity. So I'll tell you a very simple example so it'll be easy for you to understand. A simple example. Let it be myself. I am promising you that I will deliver certain goods to you on a set so-and-so date, which is worth of 2,000 rupees. I'm giving a promise to you. And now another person C is giving a promise to you that if I will deliver it to you and you suffered any loss, then that loss will be compensated by this third person, C. So technically, it is called making the loss good. That means if I give a promise that I will deliver goods to you, and if I didn't deliver it to you, and if you suffered a loss, then the third person will save you from that loss and he or she will compensate you. So this is called contract of indemnity. And there are two parties to it. One is indemnifier. The next one is indemnity-holder. So who is an indemnifier and who is an indemnity-holder? First one is the person who promises to protect you is indemnifier. And you yourself, the person who is so protected, is indemnity-holder. So who is ready to protect you? He is indemnifier and you are indemnity-holder. So these are the two parties in contract of indemnity. Now, I'm going to discuss about the essentials of contract of indemnity. In order to form a contract of indemnity, what are the essentials? The first one is essentials of a valid contract. We have already discussed many times what are the essentials of a valid contract. There should be capacity to parties, there should be free consent, and so on. So all the essentials is applicable in this case. Second one is the indemnifier promises to save indemnity holder from the loss caused to him by the conduct of the promisor or by the conduct of any other person. That means the person, the indemnifier, is giving you a promise that he will protect you from the losses that you're going to suffer. So this is under Section 124. Third point is that the contract may be expressed or it may be implied. It can be an express contract. It can be an implied contract too. Fourth point is liability of indemnifier commences when the indemnifier suffers some loss according to the terms and conditions of the contract. So, there will be a contract between indemnifier and indemnity holder, and there will be, the essential terms and conditions mentioned prior, which will be preset. And if the indemnity holder suffers any of those, loss which is mentioned under the contract, then indemnifier is supposed to compensate you. And the liability of this indemnifier commences when the indemnifier suffers the set of losses which is mentioned under the contract. If not, that's not going to cover by the indemnifier. Fifth point is contract of insurance is an example for contract of indemnity except life insurance. All other contracts of insurance are contract of indemnity. Next is rights of indemnity holder. What all rights you have if you are an indemnity holder, and which is mentioned under Section 125 of Indian Contract Act. The first point is claim for damages. That means, according to the contract, if you suffered a loss that falls and fit into the terms and conditions of the contract, you can claim for damages. You can claim for compensation under Section 125 subclause 1 of Indian Contract Act. Second point is that claim for cost of suit. Like if you file a case and you can actually seek, to get the cost of the suit, which is also applicable under Section 125 subclause 2. You can even claim the cost of the suit. And third point is recovery of sums paid under conditions of a compromise. And that is Section 125 subclause 3. You can even recover the sums or the money paid under conditions of the promise. So these are the different rights of indemnity holder. And next is right of indemnifier. What all rights an indemnifier has? The first one is right under Doctrine of Subrogation, which is mentioned under Section 140 of Indian Contract Act 1872. That means stepping into the shoes of another. And the meaning is that to sue against the third party after indemnifying the indemnity holder. That means the indemnifier first will save the indemnity holder by making the payment, making the loss good first. The indemnifier will compensate or make the loss good of the indemnity holder, and later he can sue against the third party to get the money from him. So this is the concept of contract, the doctrine of subrogation. Third point is that not to compensate for losses not covered under contract of indemnity. That means, I have told you, the stipulated, the terms and conditions should, in the contract should fit into the conditions given. If it is not falling under the particular contract of indemnity, we can't ask for the compensation for the losses. So these are the major, rights of indemnifier and indemnity holder. And I have discussed in today's class, I've discussed about contract of indemnity, example for that, parties to contract of indemnity, and rights of indemnifier and indemnity holder. This is a very important and very easy area. I hope it's clear for you. If you have any doubt, do comment below and do subscribe Legal Brain. Thank you.